Hi, my name is Corey Pollard, and I'm a personal injury and workers' comp attorney in Virginia. Welcome to my video. Today, we will talk about the employer's application for a hearing to suspend, terminate, or modify benefits in a workers' compensation case. This is the document you receive right after or about the same time as finding out that you will no longer get payments through the insurance company. It's a time of panic and uncertainty, but there are actions you can take to fight back and to get your benefits reinstated. But first, let's talk about this application for hearing and when it comes up. The only time an application for hearing is filed is after you have already proven your claim. You got hurt at work or diagnosed with an occupational disease, you filed a claim for benefits, and then the employer either accepted the claim or you went to a hearing before a workers' comp judge and won. In either of those situations, you receive an award order that shows what workers' compensation benefits you get. After the award, you're treating, you're working on your recovery, you're receiving benefits. Everything is going as smoothly as it can after your work injury. But then everything stops. No more wage loss benefits, medical treatment is denied, and you want to know what happened. Chances are good that you have also received notification, either through mail or email, that the insurance company or the employer has filed an application to stop benefits. Here's what to do. Read the form. Most employers and insurers use the standard form offered by the Workers' Comp Commission for these applications. And that form has different spaces where the insurance company can check why they want to suspend your benefits. So take a look and see why. And then read through the documentation they have. Sometimes the documentation looks pretty strong, and you will need to get other evidence to contradict it. But many times the documents are weak and don't say exactly what the insurance company indicates they say. In either situation, you should be proactive. So here's an example. A lot of times insurance companies will send claimants, injured workers like you, for an IME, an independent medical evaluation. Now, there's nothing independent about it, okay? These are doctors handpicked by the insurance company, and that's why most plaintiffs' attorneys refer to them as DMEs, or defense medical evaluations. In any event, you go to this one-time examination, and then the IME or DME doctor writes a report. And a lot of times the report says something like, sure, this person got hurt at work, but the injuries resolved weeks ago, and any disability is unrelated to the work injury. Instead, it's related to pre-existing arthritis, even though the claimant never complained about back pain before this injury or knee pain before this injury. And so what happens is that report is attached to the application for hearing, and the employer and insurer allege that you're capable of your pre-injury work. In that situation, you should take a look at what documents you have, or call your attorney or your treating physician and get copies of your reports. The reports should state your symptoms, if you've been treating with the doctor regularly and being honest, and they should also indicate what your restrictions are. That's why you're under an award. Presumably, you continue to be restricted from work. So put those documents together and then sit down and think about what you're experiencing and what your testimony would be at a hearing to fight back. And type it up and sign it and get it notarized. Although here in Virginia, there's certain language you can use to have the same effect as an affidavit, even though you don't go to a notary. But in any event, put your thoughts down, sign the document, and put it on top of the medical records. Or in other situations, you might have disability slips or job applications or letters to and from a vocational rehabilitation counselor or your job if it's offered light duty. But in any event, put down your thoughts and testimony and also any supporting documents and then submit it to the commission. Now the commission will review the initial application and your response and then decide whether probable cause exists to refer the matter to the hearing docket. The commission may find probable cause exists even though you ultimately win on the issue at hearing. But you should still try to get the application rejected to reduce the amount of time you are not receiving benefits. The commission will make a decision and then either party can appeal the docketing or the rejection of the application. The appeal goes to the full commission, which again is not deciding the case on its merits. Instead, it's deciding whether the employer has met its burden of probable cause, which is a lower burden than preponderance of evidence, which is what the employer would need to win on the actual merits. So you request review, the full commission makes a decision. If it rejects the application, then your benefits will be reinstated. If it accepts the application, then your claim and the application for hearing will be set for a hearing before a deputy commissioner. Now that's all for today. If you have any more questions, give me a call at 804-251-1620 or send me an email at cpollardjba@gmail.com. I represent injured workers and accident victims throughout Virginia, and if you're not located here, my firm can help you find someone in that jurisdiction to represent you. Hope you're doing well. We'll talk to you soon.